Good morning. Thank you so much for those of you on Pacific Coast time, for which it is still 11 a.m. Thank you so much for joining us today for our now 27th webinar on family drug courts. We're delighted to have the audience today and particularly to have the speakers who I will introduce in just a moment. If you are having issues that we can help you with, please do call the number that is on the front screen. Hopefully we're moving along very smoothly and can begin the webinar. Let me begin with the topic for today. Who are we really serving? The challenge of serving special populations in family drug courts. And as I mentioned, this is our 27th webinar. We've organized those in 5 separate learning communities and have reached 1,800 attendees representing 45 states. So we're quite happy with all of that production, and we hope that this webinar will provide information that's helpful to all of you. Let me just mention that our next webinar, Passing the Judicial Baton, will be on August 28th, and the final for this contract year, Raising the Bar in Family Drug Courts, look at the guidelines on September 11th. So we hope that many of you will be able to join us for that also. A couple different things in the webinar format today to introduce. We'll be doing polling questions for those of you who have joined us in the past. You're familiar with those, that at a certain point we'll launch the polling question. You'll have a few seconds, about 30 seconds, to respond with just a quick snapshot of the views of the participants. We also invite you to ask questions for our presenters today. You can do that through your chat box, and we will be compiling those questions during the webinar and be able to have a question and answer time at the end. Also, as you log off, you'll be getting a evaluation link that we would very much appreciate you taking the time to complete the evaluation. It helps us with shaping our series. It helps us with understanding what some of the issues are that we still need to cover. And then finally, you'll get in the next couple days, day or two, a link to the Family Drug Court blog spot, and that link is also embedded in the webinar that we'll see in a bit. But if you haven't participated or looked at the FDC blog, we'd really encourage you to do that. A lot of resources there. All of the materials that are referenced today, as well as the speaker bios and the PowerPoints, will be posted on the blog for easy access and asking questions and follow-up to any of our speakers. As I mentioned, you type and send your questions through the box located at the bottom half of your panel dashboard, and we will be, again, compiling those. Let me turn things over to Jonathan to launch our first polling question, and it's simply who's on the webinar today. The question is how you're viewing it. I'm viewing by myself. I'm viewing with one or other colleague. I'm viewing it with 2, etc. With 3 or more. Helps us with knowing what the reach is for the webinar. So 86% viewing by yourself, and a small percentage that have a couple other colleagues with them. Let me take a minute now to introduce our speakers. We're joined today by Dr. Connie Almeida from Harris County, which is Houston, Texas. Hi, Connie. Nice to chat with you a little earlier and to see your picture today. And Judge Barbara Salnitro, who is in the Queens County in New York. Jane Pfeiffer, who is part of the Children and Family Futures staff in Chico, and I think I neglected to introduce myself, Nancy Young, and I'm the Executive Director at Children and Family Futures. All right, so let's get started. And what I wanted to talk about today is kind of thinking through an approach to understand how we can look at the population that we're serving and the larger child welfare population and really focus this as discussions or information for you to take back for discussions with your family drug court team. Looking at how you are currently reaching a penetration rate and how you might want to be adjusting or modifying who's the target. Who is it that we want to serve? This is, as you all know, a really, really important issue. The exclusionary criteria or the criteria for determine who's eligible to be in the family drug court affects very much the scale at which FDCs are operating. It also means that you have to pay attention to the scope, and by that we mean what's the range of the kinds of challenges that families are encountering that we are trying to address. And the scale in terms of how we understand the larger child welfare population so that stakeholders and policymakers really see the family drug court as relevant and a reform that is helpful to the larger child welfare system in which they belong. So a really important issue for us to be thinking about. We wanted to start with just this basic information that's, while a couple years old, it's still relevant because these percentages have not shifted too dramatically in the last couple of years. We know that almost 40%, 37% of the kids who are in the foster care system are under the age of 5, and all of you on the phone recognize that as key developmental brain development, attachment issues, all of the things of early childhood that are so key. And then the adolescent population, and sometimes these are children that different jurisdictions use a different word, crossover kids, jewel jacket kids, kids who may also be known to the juvenile justice system, but that are in the child welfare system. Sometimes they're that very small population of young people who are continuing to be in foster care or group home or out-of-home care that have been there for quite some time, and sometimes they are the older siblings of young children who've come to the attention of child welfare. So we have introduced these ideas, these concepts of scale and scope for quite some time as we try and look at the family drug court movement across the country and questions to what extent is your family drug court responding to what percentage of those kids in the child welfare caseload. And we'll go through this in a minute about how you can look at those numbers, but our estimate is that family drug courts are serving right now about 7% of the child welfare population who need these kinds of substance abuse, mental health, and other services. And then the scope, to what extent are the family drug courts responding to the full range of the needs of children and families? And you see the kinds of things that we recognize, trauma, the increase in opiate use, and the other kinds of challenges that are more relevant that folks are monitoring through their communities. This idea, we have a program that you're not eligible, actually came from my personal experience. A family, very close friend, family friend whose daughter has a heroin addiction, terrifically in recovery at this point with a new little baby girl, but at that point that she was in crisis and her family in crisis, she had a 5-year-old that was placed in protective custody, and she was incarcerated. And as I visited her at jail, began to talk to her about the possibilities of the drug courts that were operating in our community. And she was very receptive to that. Actually, you know, as you might expect, her first question that she asked me is, where's her son? The first concern that she had is, where is he and how is he doing, and have I seen him yet? And as we talked about the possibilities of what was going to happen to her son and to her, we talked about the various drug courts that were operating in our community. And what I found as I began to put on a bit more of a clinical social work hat, or a social work liaison role of trying to help her family understand what was available for her to deal with her addiction issue and the issues in her family that placed her child in protective custody. What I completely was surprised to find was that we had a lot of programs, but she did not qualify. She didn't qualify for the co-occurring program. If she went to treatment where there was residential care where she could be with her son, she would be out of our county and therefore didn't qualify for the adult drug court. The family drug court was not a possibility for her because of the age of her child, that he would be 6 by the time she finished her case plan. The number of rules and regulations, frankly, were astonishing to me. So that little N of 1, I would say, in my experience about 3 or 4 years ago, really opened my eyes to, we have a program, but you're not eligible. And what does that mean for families who are trying to get access to the kinds of services that they need in order to safely parent their children, to reunify, and to go on, as she has, to be in recovery and marry and have a 3-month-old now. That is a darling little girl, I must add. So decisions about this eligibility criteria and the child welfare population has to be something that's beyond just who's funding that particular population. And that's what we find so much in early stages of collaboration, and totally appropriate. Somebody has managed and hard work, and I understand that, to have funding from the outside that says, let's try this new way of working with families with substance abuse and mental health issues that allow us to test out some new things. But also, over the last 15 years, what we also understand is that those that relied on that outside funding and haven't yet been strategic about their population and about their penetration rate and about marketing their successes to the larger child welfare services and the community run the risk of continuing to be a boutique court. We've all heard that term. And we've run into some jurisdictions in which they will say, we don't want yet another boutique court. So why do those courts stay so small? While there's a whole list of bullets, I want to emphasize a couple here that seem to be really important to speak about. One, we've mentioned already, the exclusionary criteria. What is it that happens that certain criteria is set that, for example, one of the larger family drug courts in the country I was familiar with as they were doing their planning phases, and they were very hesitant to open the family drug court to all ages of children. The fear was that there was going to be this onslaught of referrals and they would never be able to handle the number of cases that they were going to get. And in fact, as they opened with the idea that they were going to serve the 0 to 3 population, you might have heard this before, if you build it, they don't necessarily come. And that really came from that experience that they weren't getting referrals. The 0 to 3 population wasn't large enough in order to keep their dockets even full, and that they needed to expand that age criteria almost immediately. The age criteria for them expanded to under 6, and then more recently, actually after about a year or 2 of experience with that, is when they said really all ages must be served. And at this point, they have a very well-developed adolescent component and recovery support for children of substance abusers who are the adolescents. So the whole range then of by age. The other point that I wanted to emphasize on this list is about this non-standardized communication protocol. And the reason why I want to talk about that, at least in my experiences, I've worked with sites around the country, the thing that often the caseworkers and child welfare will say to us, after they've gotten used to working with a family drug court, when they say, we'll never go back to the way we were doing business before we had this opportunity to really address the substance abuse mental health issues for families, we'll never go back to that. And when you dig a little deeper and ask why, it's often about this ability to communicate. The ability to communicate between what's happening in treatment and recovery support and the court and the child welfare system. There's some very excellent tools on helping to develop efficient communication pathways between these systems. But when those communication protocols aren't clear to the larger system of child welfare in particular, it's very difficult for them to say, gee, why should I go through the extra effort of referring this family to the family drug court if I'm not getting enough back? It's what can we do for them that helps their job? I will tell you, when I first started hearing about this, I don't know, 15, 20 years ago or so, I thought, you know, that's just taking the responsibility away from child welfare, and that's really their responsibility to know what's happening with the substance abuse services for the families on their caseload. And in reality, when we understand that what's happening in the child welfare system, any assistance we can give caseworkers so that they're not doing double duty, because the treatment system knows what's happening with that family, to understand the communication and to rely on each other in a partnership that makes that very much a strong way to say our partnership is healthy, we trust each other's communication, we trust what they're telling us about what's going on with this particular family, and it reduces the noise of the communication versus very efficient ways to be able to communicate. The other point that I want to make as we turn to the next slide is this focus on the project that gets family drug courts isolated from the larger system. When we look at the child welfare reforms that are going on in the country, we're really challenged to find a place that says, and our reform in order to provide safety for kids, to have kids in permanency in 12 months, to make sure that we're using families as a way to provide support to the children if they need to be in out-of-home care. When you look at this sort of list of reforms that child welfare has gone through in the last 5 or 6 years in particular, you rarely see one of our real key strategies is a family drug court. So our emphasis as we look at this reality is to really understand what we need to be doing to help family drug courts be part of the larger systems reforms that are going on in the country to better serve families and to make sure that children have permanency. But this graphic that Russ is so terrific at finding these graphics all the time, but this picture about being very focused on the families that we serve, which are, I totally understand, can be more than full-time jobs for really anyone who's taking on these kinds of initiatives. But standing back and looking at this larger lens of the larger system is really key. Some of those issues become the inability to look at the larger data. And I do have to preface this for any of you who I'm sort of irritating with having small family drug courts and not a large penetration rate. Sometimes that's appropriate, particularly if it's a family drug court that's very intensively focused on, for example, substance-exposed newborns, FDCs, as they're sometimes referred to, and that you have a partnership with the hospital that says we're about reducing our hospital costs on substance-exposed newborns. Or there's a new population, particularly we're hearing now, obviously, about the opiate addiction and neonatal abstinence syndrome and what's going on with with this new epidemic of substances, to make sure that those kinds of services are in place. Sometimes that means that drug courts have to stay at a smaller scale. But this is the challenge, is the balancing act of understanding what the need is in the community and the capacity. And this idea of opening doors. What would it take to open the doors of the criteria of who gets into the family drug court? We're going to talk about a little bit in terms of a way to think about that. The 3 M's, and the one that we're going to cover today is really about mapping out the needs. And in future webinars, we're going to talk about and provide some information about matching those needs through services and monitoring progress. So the 3 M's of mapping, matching, and monitoring. When we think about the framework of determining the target population, there's 3 kinds of things that we think are important for every family drug court to really know. Who's in the child welfare population, meaning basic demographics, but importantly, their service needs. Who's in our family drug court population? We've done some analyses recently on some family drug court data that we have, and trying to look at who, by just race and ethnicity, is in the community, who's in the child welfare system, and who's in the family drug court. And the mismatch, as you might envision, is uncomfortably uneven. So thinking about who's in the child welfare population, who's in the family drug court, and who's in your community are basics about how to look at the population that we're serving and how that targeting might be used to be more effective. So this idea of looking at the system as well as mapping out the needs in terms of families' needs and challenges. And I won't go through all of these bullet points. They're really meant to be a bit of a guide for you to think about how would you get that data. And if you are taking on some of these challenges and we can be helpful in the future, we really appreciate you just reaching out and saying, give us some help with trying to understand our data and looking at our system and looking at our family strengths and challenges. As we have heard many times, well, we don't have a researcher, we don't have the capacity to look at our data in many ways, and one of the things that we've recommended and had many people do is just read cases. Get a sample of those kinds of issues in terms of the child welfare population, who's in the family drug court, and then the basic demographics that are available in your community. How do you know your population? Do a sample. Just read some cases. Decide which of those things are really key questions that you need to know. Demographics, including the age, race, ethnicity, age of the parents, the kinds of challenges that you frequently see. Substance abuse, mental health, domestic violence, developmental services for the children, trauma services for the children and for the parents. You'll find that those common themes often come out, that those are the kinds of needs that you'll find through reading those cases. So when we think about the kinds of needs, here's a little bit of math. You know, many of us will say we're social workers because we didn't do so well in math. So this is simple enough math, I think, for all of us, even those of us that are social workers, not mathematicians. So on average, we know that in a country, I'm going to run through these data because the challenge, I think, for you is to find out what these data are in your own community so that you know what is your penetration rate for serving the families with substance abuse in your community. Say in your community there are 50 parents in your family drug court. And we know about now 360, that's when we did this, 345 family drug courts. There's 17,250 parents in the country. We use a conversion rate of parents to kids of 1.75, so 30,000 children. You probably, in your family drug court, could count much more specifically without these kinds of estimates of how many parents, how many children. And at this point, about 408,000 kids in out-of-home care. You, too, can find out how many kids in out-of-home care in your community. And if you know what percentage in your community are affected by parental substance use disorders, you can replace that 70%, but just a pretty good estimate, but we found holds up over the years to give an estimate of how many of those kids in out-of-home care are affected by parental substance abuse. So if you take those 30,000 children that are those parents, and divide that by the 285,000 that are in the system, the 30,000 are those that we estimate being served in family drug courts, we're getting about 10% penetration rate. And so the question has to be, what about those other 90%? What happens to them? And again, I don't want to belabor this too much with the data, but understanding risk and needs and how to understand the penetration rate becomes most critical as you're thinking through if you're reaching 10% of the population in your child welfare system, how would you then be strategic about which population you would see next? We define risk and need a little different than they do in the criminal drug court, but an idea to think about as you're reading those cases, what are the risk factors and the need factors that you need to be aware of, and what's the size of the population that fits into these 4 different quadrants of high risk, high need. If we're thinking about the way child welfare typically defines risk factors, multiple priors, children under 5, criminal history, parental substance abuse, high needs, multiple treatment episodes, not having stable housing, they've identified that there's a substance use or a serious mental illness, other co-occurring challenges that the family has, lack of supports and resources. Again, for each of these quadrants, you can go through and decide, in our community, the risk factors include this, or the needs include that. And this is the proportion of families that fit into each of these quadrants, low risk, high need, and then those that are low risk and low need. And being able to understand what those numbers are allow you to do some targeting in different ways than I think we've thought about in the past, where it's been some criteria about who gets in might be based on something other than the risk to the child or the needs of the family, and making those determinations about where you serve children and which families are in the drug court is the challenge that we're presenting today. We're not going to spend a lot of time on this issue of matching those needs through services or monitoring progress. As I mentioned, we're going to talk about that in future webinars. And let's do one more, Jonathan, after monitoring progress, and turn to our next polling question. So the question to all of you, to what extent is your family drug court looking at your target population and thinking about high-risk clients and high-need clients? And if we could take about 30 seconds to respond to this polling question. Okay, we have about 70% of you that responded, and about a third, not quite certain if this kind of approach to be strategic about the population is taking place in your community. And nice that about a quarter of you have said that you've expanded your eligibility criteria. And we're happy to see that there's 20% of you who are going to be in touch with us about getting some help. We hope this webinar will be helpful, and we hope we can be helpful in the future to be able to get you some information that would be of assistance to you. Thank you so much for your time today listening to my comments. I'm going to turn things over now to Dr. Connie Almeida. Connie, you will have control of the slides.
Great, thank you. Good morning and good afternoon to several of you on this call. I have to say I'm delighted to be part of this presentation and to share with you how we've taken a infant toddler court based on the 0 to 3 model and expanded it and integrated into a family drug court. But I also have to say I'm also very delighted to be learning from our other panelists. because we too struggle with a lot of these issues, and so this is great. I'm taking notes as I'm presenting. So I have sort of an interesting role. I work for Fort Bend County as Director of Behavioral Health Services, but we have an interlocal agreement with Harris County. So there's actually an agreement between two counties to support this initiative. And so I'm able to spend part of my time working with Harris County, and specifically the Family Drug Court that has expanded to include the Infant Toddler Court. Oh, I'm sorry, there is a delay in this, so let me, thank you. So basically the whole Infant Toddler Court initiative is based on the importance of relationships. The parent-child relationship, as we know, is core to a child's development, and we've really created this initiative to really increase the awareness and increase the services to help heal that relationship and support that relationship. So some of this will be redundant with Dr. Young's presentation. I'll try not to be too redundant, but would like to emphasize a couple of the things that we do know. We know that parents of maltreated infants often have multiple risk factors, including poverty, substance abuse, mental illness, domestic violence, and of course limited social support. And of course we know that those issues impact a parent's ability to be responsive, dependable, and available to their children, which is the core of healthy relationships and necessary for a child to develop a healthy attachment. So what we find in child welfare is that maltreated infants and toddlers are at risk of developing disorganized attachment, later psychopathology, and we all know this. We all have heard too many times about the cradle-to-prison pipeline in our country. So in order to optimize this early child development for children in the child welfare system, we often need to focus on how are we going to heal that trauma, how are we going to provide for a corrective attachment experience. So part of the challenge of doing this is when you have parents that are struggling with a variety of other issues, of course, like substance abuse. And one of the things when I first came into contact with the family drug courts was there was this almost exclusive focus on the parent's recovery. And I would sit in the family drug court and there would be no discussion of children's services. That was often in another court or another setting. And of course that was very disturbing to me and to several other folks. And again, Dr. Young has talked about this, so I really don't need to repeat some of this. We know that many young children are in our foster care system. We see more and more of those children coming into care. The majority of the reason for the placement is parental substance abuse. Many of them during prenatal development have been exposed to drugs or alcohol. And it's interesting, the statistic, many placed within the first month of life. So that means we're taking children out of their parents' custody, often at birth, and placing them in an out-of-home placement. And when I first became involved with these projects, it was really alarming to see that often months would go by without there being a parent-child contact. I'm really pleased to say that that has changed. Now we see many more children remain with the birth parents, many more children placed with relatives, and visitation and parent-child contact is a priority. Okay, many of these statistics you already know, so we can go on to the next slide. And this is interesting. Texas is a big state, and Harris County is the largest county in Texas. We have over 5 million people in Harris County. Fort Bend County, the second largest in this region, 6, and Fort Bend County has about 600,000 people. So this region is obviously larger than some states. As you can tell, in Texas we have many children in care. If you look at Region 6, which again includes Fort Bend and Harris County as well as some other counties, but we're going to focus on that since the initiative is really a partnership between Fort Bend and Harris. There are 5,900 children in Region 6 in care. That's over 21% of the children in the entire state. In Harris County, almost 5,000 children in care. And that's actually a slight reduction from the 2011 data, so about 80% of the children. And these statistics mirror some of what we find throughout the country. Many children are under the ages of 0 to 3. The CPS data actually pulls at 0 to 2 and then 3 to 5. But again, what you're seeing in that is half of the children in CPS care are birth to 5-year-olds, so very young children. This is challenging because what we found in Texas was really a limited provider capacity focusing on these young children. So we've been working to enhance that. So let me tell you a little bit about where we started. And we had a pilot site. We were actually the first demonstration site for 0 to 3 court teams project, and many of you know about the 0 to 3 organization out of Washington, and I believe there's actually some references and resources at the end of this webinar for the 0 to 3 project. But we were the first demonstration site. Judge Ronald Pope was the judicial leader out of the 328 District Court in Fort Bend County. Fort Bend County, much smaller than Harris County, provided the opportunity to really develop a pilot site. And next slide, please. And to bring together a court team. So a partnership between the judge, a community coordinator, child development expert, which at that point in time was, I became involved with Judge Pope in the court team project in 0 to 3. And we brought in several of our stakeholders, one of them being CASA, which has been an unbelievable resource for the court team. And what we did was really bring together these various stakeholders, attorneys, provided specialized training for attorneys, both the ad litems as well as the parents' attorneys, and we increased the frequency of monitoring. We moved from the statutory hearings, which are often 45 days, 90 days, but not frequent enough, as we know, to monitor a child's development, to monthly case reviews. And then, of course, we started adding child-focused services, early intervention services, and then started to look at developing, and this is a work in progress. Believe me, we struggle to try to get these things in place, and some of them we've done a better job with, others we haven't. Continuum of mental health services. A couple of the things that we were able to implement was the visitation practices and really talk about visit coaching, positive and productive visitation, really focus more on the assessment of the parent-child relationship. We know that parents are often referred to parenting programs, and we know too well that often the certificate that those parents get during those programs really has minimal impact on their ability to take care of their children in real-life situations. And so as we know that we're all making a move towards evidence-based practices and providing those services. Okay, next slide. So one of the things that we've done, well, just in summary, is I'll talk a little bit more about the visitation later on, but in summary, this infant-toddler court is a specialty court, a therapeutic court that really focuses on helping parents stay connected to their children, learn about their child's needs, respond appropriately to those needs, recognize the impact of their behavior and their emotional availability on their children, and make better decisions to have healthier lives for themselves and their children. And really, I think this summarizes the interventions that we try to provide. Connected. What is that parent-child relationship? What opportunities are we providing for parents to stay connected? learning about their child's needs. You know, do they recognize their child's developmental needs? As we know, many of these parents have not had, many of our parents, actually, when we looked at a snapshot of many of our parents, half of them have had CPS involvement before. Some of them were in CPS, many of them. So these parents have not had positive parenting experiences themselves, so they often need to learn about parenting. So what we did was, so Fort Bend County, as I mentioned, we were able to basically, in Judge Pope's court team, we were able to serve all the children in Fort Bend County under the 0 to 3. However, in Fort Bend County, that's about 24 referrals a year. Very manageable, very appropriate for a pilot site. However, we knew that in order to be able to have any impact on the system, we would have to engage Harris County, and really we focused on two communities, the outreach to Bear County, because they had a history of really developing specialized services for children in actually children's courts, and then Harris County because of the size of Harris County, and also because we were within the same CPS region. So we were very fortunate to have great partnerships between our judges, great partnerships between our service providers. So we had several courts that were interested in the expansion of this model and looked at building an infant toddler court in Harris County. But what we quickly found, well, we didn't have any new money to do that, but then we started to look at what existed in Harris County, and we realized there was an existing family drug court. Judge Bonnie Helms from the 247th Court was able to visit with Fort Bend County and realized, I'm already doing this. I could do this. All I would have to do is add this children's component and integrate it into the existing family drug court. So I had the opportunity to work with Judge Helms, and when we started looking at the data, like who are we already serving, in the family drug court in Harris County, we realized all of those parents at that point in time had a child under 3. So it was a perfect opportunity to build in this component. I also have to tell you, as sort of a side note, when Dr. Young was talking about exclusionary criteria, when I started reviewing the criteria for the family drug court, there was this reference to florid psychosis. And it's interesting because I've been a psychologist for, gosh, almost 30 years, and I had to look that up. So I thought, well, if I have to look that up, other people probably aren't very clear on what that exclusionary criteria means. So we've changed that. But it's interesting how, you know, we do something because it might be right at that same time, and then we don't reevaluate those criteria. And I think that's a really, really important thing to note. So anyway, okay, so this Infant Toddler Court Initiative is now a partnership between Fort Bend and Harris County. And really what we focus on are early intervention, stability and placement, and providing early and appropriate services. I also want to mention, as Dr. Young said, that there's many risk factors that these parents experience. And I know that we're going to be talking about this also later on, is these families need specialized and integrated services. We know that co-occurring disorders are often the rule, not the exception in this population. So we need to address the domestic violence, the mental health, and several of the other issues. So our goal is to heal trauma, support, and preserve families when possible. And of course, the ultimate goal is to divert children from further involvement in the child welfare or the criminal justice system. So back to who are we serving in these family drug courts? When we looked at, this is a typical, DSM-4, I'm sorry, I should say DSM-5, but, DSM-4 diagnosis of a parent in a family drug court. I mean, this indicates not only the multiple risk factors, but the co-occurring disorders that are going on, and then, of course, all the psychosocial stressors that these families experience. So, as you know, This is just the vulnerabilities and the risk factors, substance abuse, domestic violence. One of the things that we've done in our family drug court, infant toddler court, is increase our attention to domestic violence, also and intimate partner violence. We not only found that many of our families were struggling with mental illness that needed to be addressed, we also find that about 50% to 75% if they had a history of domestic violence that needs to be taken into consideration. Okay, and just to emphasize, next slide please, to emphasize, we know that the impact of parental substance abuse on these children. I mean, what happens when parents are using drugs, they have a difficulty protecting their children, the failure to respond to their child's emotional needs, failure to develop a secure parent-child relationship, and a failure role model. So again, parental substance abuse, which is the core issue that we're dealing with in the family drug courts, has a direct impact on the parent's ability to respond to the child's needs and to develop a secure and nurturing parent-child relationship. So the child's needs have to be a core component of the family drug court, as well as the interventions for those children. We know this. Dr. Young already talked about this. It's the main reason that children are coming into care, especially young children. And then I'm going to talk a little bit about the FIC-ITC. What we've done now is the family drug court in Harris County actually started in 2004, but then in May of 2011 we added the infant-toddler component, again with the emphasis on the children and the parent-child relationship. And to date we've served 58 adults, 82 children. 58 children are ages to 3 because, again, that's one of our target populations that we're focusing on. I do have to say, as Dr. Young has said, although our focus originally was on the 0 to 3 population, we are now looking at expanding that target population to include children 0 to 5. We've already done that in Fort Bend County, and that's the plan in Harris County. And basically, just would like to emphasize that many of these adults have co-occurring mental illness and history with CPS involvement themselves as children, and domestic violence, about half of the cases. Just a little bit about the children. I'm at the last reporting, I was pleased to see that we looked at 13 of the 0 to 3 children. 7 of those children were placed with their birth parent, and 6 were placed with relatives. And we had 3 children placed with relatives that the mother was residing in the same home. So they were under the relative's custody, or but with the parents present. And that is a significant change in our system. And really a focus on that placement stability and providing opportunities for parents to have contact with their children in a safe environment. I do have to say that one of the criteria for this court is that the goal has to be reunification. So if the goal is termination, they're not eligible. So we've already determined that the goal is reunification, or at least the primary goal is reunification. And also, if there's any criminal assault charges, they're not eligible for the program. Dr. Young talked about this in terms of matching needs, and I just think it's really important because what we've tried to do is develop a infant-toddler children's services module that really talks about matching the needs of matching services to the needs of the child and to the needs of the parents. So just briefly, I mean, if we look at these children have emotional needs, medical, developmental needs, physical needs, and educational, and of course, these are all, none of these are exclusionary. But what we're talking about, and some of the things that we have added as part of our infant-toddler court initiative and that we've integrated into the family drug court is a parent-child relationship assessment. and parent-child focused interventions. We now have a parent-child relationship assessment on all of the 0 to 3 children that are served by the Family Drug Court. So right from the beginning, we are asking, what does this relationship look like, and what kinds of interventions do we need to do to focus on this relationship, to help that parent know about their child's needs and be able to have the skills to respond to those needs in a consistent and healthy manner. We really have also introduced visit coaching, which we use as a model to enhance opportunities for parent-child contact and to provide appropriate and therapeutic visitation. And all of our children have a minimum of 2 visits a week, have the opportunity to visit twice a week. Many of them are having much more contact than that. And the other thing that we've really focused on, of course, is safe and stable living environments. Minimize the changes, the out-of-home placements, the transfers. We know that those things are traumatic for children. We do not want to re-traumatize children by moving them. There are times that we have to move children, of course, because of safety issues. But again, there's a lot more planning going into that and a really much more focus on providing that stability in an environment. So we have to do the same thing around parents. And this is complex because our parents are very high risk, high need. We have parents that have multiple financial stressors, medical issues, trauma, and again, the substance abuse and the mental health issues. So we try to address that and provide both substance abuse and mental health services, but the lack of integrated treatment is a real problem for us. Try to really focus on specialized counseling and trauma-focused services. We also work very closely with aid to victims of domestic violence and provide legal support in terms of safety plans and other things to really help the parents be able to protect themselves and their children. Okay, next slide, please. I know I'm going through these pretty fast, but I have limited time. So, in terms of monitoring progress, what do we do? I mean, we focus on the child, we focus on the parents, when we focus on the courts, and what are we doing in terms of the system. I mean, of course, permanency is really our ultimate goal in reducing the reoccurrence of abuse, stability in placements, visitation opportunities, early intervention services. Can we get more services to these children? Can we increase parent-child contact? Can we reduce the number of out-of-home placements? And can we get these children to a permanent, stable environment faster? In terms of the parents' recovery, are they engaged? Can we retain graduation? Identification and reduction of psychiatric symptoms, so we do a mental health screening right at the beginning. And then again, we also do a domestic violence screening right at the beginning and refer them to appropriate services. Employment is a big focus, how to get these parents employed and so that they can sustain themselves and their children. In terms of the court and the court team members, one of the things we've really done is the training of team members and the integration of child-focused services into the staffing. In terms of monitoring progress, this legislative session, I'm so happy to report we've actually introduced some new legislation around visitation in Senate Bill 352. And I would encourage you, if you have the opportunity or interest, to look at that. But it talks about least restrictive, it talks about developmentally appropriate visitation, talks about collaboration, and there's just some great language introduced there. So this really was a systems change and a positive systems change that we've seen. What we're looking at now is how we can take what we've learned, first of all, in this Fort Bend court team, which has migrated into Harris County and into the Family Drug Court, but how do we really develop a children's module? If it's young children's module, an infant toddler module, maybe it's a module for older children transitioning out of the system, but how do we develop a children's module that can be integrated into these other specialty courts? That's the goal. That's how I feel that eventually we're going to be able to reach some more of these children in the child welfare system, because obviously our penetration rates with the infant toddler court are very, very low. I mean, Harris County has, I forgot what I said, 1,100 children, birth to 2 in custody just in Harris County, and we're serving, 50 children or 27 children. I think the total was 82, including siblings. So we really have to work on that. That's one of our challenges. Just briefly, one of the things that we have been very successful in is partnering with several local and state organizations and providing a local conference. We do this at low cost and, I believe, high quality. This year we were able to bring Judge Edwards in, who of course is the leader nationally on some of these initiatives, as well as Dr. Lynn Katz from Miami, Florida, Dr. Shaw, Prachi Shaw from the University of Michigan. So we've just developed a great grassroots initiative to provide training. This year we partner with the State Bar of Texas, and we provide a 2.5-day training and reach about 600 people. So that will continue, and it's been a great way to focus on this, the need of young children, and to provide great training, again, to child welfare workers and several other partners. Next slide, please. So just in ending, just some of our challenges, like many of you, our target population, we're focusing on a high-risk, high-need population. We have many folks with co-occurring disorders, and there's a lack of integrated treatment. Still struggling with the lack of wraparound services and linkages to services and aftercare, which is critical. And truly, we have incompatible systems. We have judiciary systems, child welfare systems. We have substance abuse treatment systems. We have mental health. And so how do you really integrate these systems? The development of specialized services that are not sustainable. I mean, that's one of the problems. We can add services when we have grants. How do you sustain that? We're looking at those things. I think that's an important question to ask right at the beginning of any project. And identifying outcomes and being accountable. Truly, what are the outcomes we're trying to achieve? I did want to mention one of the things, I think it was one of the slides that I probably skipped over. One of the things that we have been successful in doing is we have a management information services. So our reports are generated. We have this, so we have staffing reports that integrate all the information. One of the things that we have done is actually included a children's module within that staffing report. So our staffing report for the Family Drug Court includes information on visitation, on parent-child relationships, and on what's going on with the children. That is significant because that's a systems change that is sustainable regardless if there's funding or not, because now it's been integrated into the regular staffing report. I just wanted to mention that. So what can we do? First of all, we intervene early and appropriately. We have a lot of challenges, but there are stuff we can do. We can provide trauma-informed care. We can focus on healing that relationship. We can ask the question. Judges can ask the question. The team members can ask the question. Tell me about the parent-child relationship. Once a judge asks that question, believe me, people pay attention. Address the complexity of needs experienced by the parents. Provide a continuum of services. Plan, communicate, evaluate, and follow up. And I think it's really important, and I want to emphasize this, that where do we start? We always start at the beginning. We can't understand what is impacting, what's going on with a child and a family until we ask what happened. What happened to those parents? What was their experience as children? It's so important to look at those and to look at what prenatal history, parents' early experiences. It's also important to look at their treatment history. You know, what's worked in the past and what hasn't worked. Let's not reinvent the wheel and try to do more of the same thing. Let's really look at doing something different. So I apologize if I went really fast through those things, but I'm trying to be sensitive to my allotted time. So thank you so much. Oh, and I'm sorry. And I'm now turning it over to the Honorable Judge Cilintro. Now, I pronounced it wrong, from Queens, New York.
Good afternoon, everyone on the East Coast, and good morning, I guess, still, perhaps to others. I am Judge Barbara Salinitro, and I sit in Queens County, New York. And in terms of where we are, where Queens County is, let me say that if you have ever taken a plane into New York, you land in Queens County. That's where JFK and LaGuardia airports are located. We are one of the 5 boroughs of New York City. Our population generally in Queens County is 2.2 million residents, and it is the most ethnically diverse urban area in the world with that population. We have 46% of our community is a foreign-born community, and people speak over 138 different languages in my county. That does become a factor in handling many of our cases. It's a very culturally diverse area. We have approximately 3,300 children in out-of-home care. In the context of our family treatment court, I'd like to explain just very briefly, if you can move to the next slide, how our system operates. We did establish a treatment court in 2002. I began planning that court the year earlier and have been sitting in treatment court since 2002 as a component of my judicial responsibilities. I handle treatment court 1 day a week, and on the other 4 days I handle predominantly general child protective cases, but that obviously can also include custody and visitation matters and a variety of other complex issues. We have the capacity to serve over 100 families, and going back to 2006, we had the highest number of participants that year, which was 131 families. At the current time, we have approximately, I think, about 40 families in our system with about 66 children. Our court system in New York tends to be litigious and adversarial. And in that context, because I know it is different from many other jurisdictions, I want everyone to understand that everyone in the court is represented by counsel. So we have the Child Protective Services there with workers who are represented by a lawyer. Every parent, whether they are a respondent, meaning the parent who's accused of the neglect, or a non-respondent parent, have counsel. And all of the children have counsel. It can be one lawyer for a group of children where we have 3 children and 3 lawyers on those cases. So there is a lot of participation by attorneys. There's one judge who presides, it is me, over the treatment court cases and in the dependency. So the topic of my discussion is the eligibility criteria and why we are moving and changing our process to accept co-occurring populations. As was referenced by Judge Almeida, much of the research shows that the high needs, high risk population seems to benefit most from the treatment court modules. And what we learned in our process was that many, if not most, of our population of parents did have some sort of mental health diagnosis. At the inception of our treatment court, we intentionally excluded cases where a parent had a formal diagnosis on any of the axes, a formal mental health, mental illness diagnosis. We felt that that was something that we were not capable of addressing in the treatment court. Ironically, we learned very soon that we were addressing it because, as I said, most cases had families with a complex history of mental health issues. it's actually taken us, 10 years to get to a place where we felt that we needed to formally change our criteria to include cases that had a formal mental health diagnosis in them. And in order to do that, we needed to spend considerable time as a team preparing for the shift in the type of treatment and intervention that we were going to be using. So if we could move to the next slide, I will just say briefly that in the context of looking back at the 0 to 3 and the 0 to 5 population that Dr. Almeida was referencing, the cases that were coming into our treatment court and have always come in to our court were focused upon a child neglect case that accused the parent of neglect based upon substance abuse. The age of the child was never a factor. So from the initial inception of our program, we had infants, newborns, as well as teens, and we continue to have that process. It was based upon the substance abuse, not the age of the child. So if we can move forward. Last year, we began a process of formally transitioning our treatment court module to include the diagnosed mental illness co-occurring disorders. It has taken us from last year until this year to work our way through that process. It has been a team progression. As the slide reflects, in approximately February of 2012, myself and my project director began to discuss the expansion of our program. In the context, again, of what has been referenced as a future program about the role of a judge, I think it is extremely important for the judges to take a lead role in moving any of these changes forward, because whether a judge likes it or not, their opinion counts, and their opinion is a big factor in how the process moves forward. They are absolutely a part of a team, and as I will show you, we remain always open to team opinion and discussion, but the reality is that a judge's voice is given great deference, and so it is really critical for a team to have a judge that is not shy about stepping forward and moving the process in the direction that's needed. I'm fortunate also to have a great project director to partner with. So from February of last year, we took about 6 months talking about how we might want to expand, and then began in the fall of last year bringing team members in, inviting people to sit on a committee to work through the variety of issues that inevitably we believed would come up and did in fact come up, and then others we never even contemplated that came up, to formulate a new protocol for our treatment court. We had intended to hold a meeting at the end of October or very early November, but here in the Northeast, Hurricane Sandy intervened and we had to delay that. And we had our first committee meeting at the end of last year in December. In the process of deciding, we included as part of our committee the lawyers that I mentioned previously. So we had people from ACS, we had, which is Child Protective Services, we had lawyers who were advocates for the children, advocates for the parents, we had case managers that we consulted with, both case managers that worked directly in our treatment court, as well as the service providers, the administration in our service providers, as well as case managers in our service providers, to sit at the table to discuss all aspects of how adding the co-occurring population into our program would impact it moving forward. As an example, in my treatment court, a parent stands up and makes an admission to child neglect when they, prior to the case formally entering drug treatment court. And that child neglect means that they are standing up after a full allocution of their rights and saying, I was using drugs and getting high while I was responsible for caring for my child. And that impacted the ability to care for my child, for example. The question, one of the questions that came to the table was, would that be an adequate admission? Would the Child Protective Services legal office accept an admission to substance abuse rather than an admission to the component that included mental illness? And that was a conversation that took a long time to work through because of the dynamic between the various advocates, as well as how an acknowledgement of a diagnosis of mental illness could impact that case down the road if it had to move to a termination of a parent's parental rights. So there were a lot of discussions, both legal and clinical, that occurred at that table and took months to work our way through. If we could move to the next slide. So this is a context for what the committee looked like when we started, and really throughout it continues to this day. Our goal actually was to begin accepting cases right after Labor Day. We've actually met that goal because we accepted our first case about a week ago, a case where a mother and father were accused of neglecting their children because of child neglect and bipolar diagnosis and clinical depression. And so we've just begun the process of accepting that case into our system. And like I said, we've met our goal on that. So we had me, myself, the judge, my project director, the attorneys, the treatment providers, and the mental health providers all sitting at the table. What this slide depicts really is how we, the various paths that we took to getting ourselves prepared to implement the new programs. Mostly with the work, but through the work of my project director, the networking to identify suitable service providers took place. Mostly with the work of my project director, the trainings took place. What my project director was able to do was identify within our community hospitals and clinics and rehab programs that would meet the needs of this co-occurring population. My project director was able to bring those clinicians to our court to work with the committee and train the participants in our treatment program. Site visit. Not too far from my court is our Queens County Criminal and Supreme Courts. You can walk from my family court to those courts. In the Queens County Criminal Court, there is a mental health court and a veterans court run by one of the judges in that courthouse. And we arranged to go over and spend the afternoon watching the mental health court, how that judge handled cases, adult cases, that mental illness components. She also, as I said, had the veterans court as well, all of these courts really integrating the trauma-informed care principles and many of the protocols that overlay what every family needs. Keeping in mind, of course, that all these parents and people, adults who are in the criminal court system, I wouldn't say all, many of them have families. And just as easily, under certain different set of circumstances, could have been sitting in my court. The technical assistance component is actually ongoing with Jane and with the help of the Center for Children and Family Futures. They have been integral in working with our team, and again, particularly my project director, in guiding us along the way as to how to move our process along. As I mentioned, how integral it is to have a leader, a director who can focus the development of the program. It was she who attended the meetings, did the networking, reached out to the service providers, did all of the integrating of services. I think I've more or less addressed some of those things already. So if we can, my project director was able to invite a series of clinicians to our courthouse to educate us and train the staff on what to expect as we were expanding our treatment options. So some of the types of programs that she incorporated into our training are listed here. One of the key pieces and the new sort of direction that you hear about with any type of rehab programs is the trauma-informed care. And so you'll see on this list of programs a number of programs that included approaches to trauma, the innovative approaches, further down the trauma-informed care principles. What is interesting and new, if you look at the third bullet, is equine-assisted therapy. Holliswood Hospital is a psychiatric hospital in Queens County. This is a very new system that they've been developing. Our treatment court has not been exposed to the equine-assisted therapy to this point. That would be a very interesting component for me to learn about if we get to a point where we're implementing that as well. But this is a list of the types of programs that my team members were trained on in anticipation of moving forward with the co-occurring disorders. Okay, let's move to the next slide. And I've already mentioned that we went to the Queens Mental Health Court. That was really reflected in the site visit previously. Everyone in the team participated. There was a full overview, and we observed the court proceedings. It took about a half a day. When we left, we met back at our courthouse to discuss what we wanted to, what we learned from that site visit and how we wanted to implement some of what we learned there. And so what we did take away, as it reflects, is that as we begin our mental health court, we are not going to exclude any diagnoses. We were left with an understanding that we may actually be more successful with some as opposed to others. I'm not going to go beyond that, but we decided that the protocol that we would begin with would be to keep the eligibility expansive and allow in any diagnosis and figure out as we move along what we are prepared to and capable of, moving forward with. So we also took away that we would be switching the types of psych evaluations and assessments that we would be using. We would be adding to our team of stakeholders a psychologist, and that we would need to add additional agencies in to assist us with services. I think at this point, Jane is going to talk a little bit about the last component of those four pieces, which was the technical assistance.
Thank you, Judge Salanitro, and welcome everyone. So several months into the process that Queens County Family Treatment Court was undergoing, we became involved, and for the last 6 months or so now, we've been providing some technical assistance. You can see on the slide the overview of what we've provided. Through conference calls, we assisted in reviewing their process up to the point we became involved, and we provided support materials and worked with the court to assist them in moving forward and using the support materials in their continued planning process. We, as I say, we assisted in developing a plan to move forward, and specifically as it relates to the site visit that they had to the Queens Mental Health Court, we were able to create a guide for their visit that was a set of questions. These questions were based on the recently published Family Drug Court Guidelines document that you'll hear about in a minute and some of you are aware of. And this really aided their visit by helping them identify key areas of difference between the mental health court and their family treatment court, and also highlighted important considerations and some of those similarities and ways in which they could incorporate those lessons learned for their continued planning. So this is a list of resources and publications, a partial list of the materials that we have provided to the Queens Family Treatment Court team, and it has been instrumental in crafting and processing and implementing some of what they're learning both from these publications and resources and the other work that they've been doing in their planning. We'll talk a little bit about a couple of these in a moment. The goal really in providing these is to help them identify some additional ways to train the planning team, and then you'll notice the training toolkit was particularly instrumental in adding to their ongoing learning process. We wanted to, although this list is fairly overwhelming as it is, I think, but we wanted really to provide resources for the questions that are not only raised throughout this planning process, but as they begin the implementation process and with the specific cases that they're beginning to take during this pilot phase. Oh, I maybe should have mentioned that those resources and the ones that you'll hear about in just a little bit are all available on our blog, so the links are all available there as well. So our future goals for technical assistance with the Queens Family Treatment Court, our plan is to, moving forward, to assist them in conducting a systems walkthrough. And this will be an opportunity for their team to step through each point in their process from intake throughout, and to view it from a co-occurring perspective, that is an individual, a parent who has a co-occurring disorder, and to be able to view it from that lens. With the knowledge that the team already has, will help them identify barriers and obstacles that currently exist. And although many of the practices that are in place, of course, are mandated, and therefore they really can't be changed, there really may be ways to modify, for instance, the method or even the location that some of these events occur, which would allow parents to and families to have the most optimal experience that they can in the process. We're also going to assist. We're going to work together with the Queens Family Treatment Court in refining their eligibility statement and provide policy and practice examples from other courts and others who have gone through this, and really provide opportunities to have conversations as well with others who have been through it. So that cross-site consultation is that opportunity to work with other courts and to talk about that. And then, as I mentioned, the idea that as they begin to bring cases into their program, they undoubtedly, as all of us know, whenever you're in implementation, during an implementation phase, you're learning things and questions and issues are being raised that maybe weren't at first anticipated. And so we'll be working with them to process that pilot experience and to take the lessons learned from that and to modify as necessary. And with that, I'm going to turn it back over to Judge Salanitro. Thank you.
So So thank you very much. And moving forward now, our treatment team has to factor in how our process will be different. The first bullet reflects additional screening tools. Our treatment team internally to the Queens Family Treatment Court, our case managers that work on site, as well as the treatment providers that we collaborate with in the community, will be adding additional screening tools. The modified mini screen, the mental health screening form 3, the primary care PTSD screen, again reflecting on the need for trauma screens and assessments, and then the immediate needs assessment based upon the trauma screen will be added in to our initial evaluations on eligibility and also identifying a direction for the referrals for services. Our treatment providers will become more actively involved in the court process. Through our preparation and meetings, we have gotten feedback from our treatment providers suggesting that they want to spend more time in the court process. Not only do they want to learn more about it, but believe that the more physical involvement in being in the courtroom and being more understanding and involved in our process will make the dynamic that we share between a courtroom environment and a clinical environment be more effective. The referral forms that we will be using will become more thorough to add the detail of mental health and trauma history. We have been contemplating whether or not we will need an entirely separate day or an entirely separate track of time for me to physically process in court the cases that are defined as the co-occurring population cases. We have not yet figured out whether we're going to do that or how I might come up with more hours in my day or during my week to be able to separately track those cases. But we do believe that we've already learned over all these years, and I'm sure many of you who are doing drug courts agree, that these cases are very time-consuming in and of themselves and will frequently take much longer window of time than a child protective case that works along a traditional track. The co-occurring, we're trying to decide whether or not we need to separate those out and track them. Again, what I have to come up with is more hours in the week to be able to figure that one out. We're still playing around with that idea. Okay, so moving forward now to the partnerships. These are a list of organizations that we are now becoming more committed to working with in Queens County. And FEGS is Mental Health Clinic. The Long Island Consultation Center is an OASAS and Office of Mental Health program, which to whom we send many of our participants. One interesting piece, and I think it's Long Island Consultation Center, is one of the few facilities that will take an undocumented parent, which is important for us. And again, we have BLULA, which is an OASIS and OMH. And the Firehouse Center, I'll mention quickly, is a facility that is close proximity to our courthouse that offers the full medical clinic, gynecological, dental, physical exams, and also has the mental health component to it, which we are blessed to have very close to our courthouse and will be able to take advantage of for many of our clients. What challenges still exist? Well, it's global because we really are just at the implementation. We've really just opened the door, as I said, taking our first case. So we're going to have to figure out the functional capacity in terms of the parents, their diagnosis, their ability to use the tools, the ability of the court itself to be able to address their needs in an effective way. we've moved forward. That's my contact information. I would strongly suggest to any of the participants in this program who have detailed questions about moving your program forward to expand, to contact my project director, Vula Correa, whose contact information is listed on this slide. She's done an enormous amount of work in making this happen for our team, and she deserves a lot of credit for that. Okay, so I think we're going to move to the next slide, and there's a polling question for the participants. Question number 3, what would you consider to be the greatest challenge in expanding services to clients with co-occurring conditions in your family drug court? Take a few seconds to answer that question.
We have about half of you that have responded at this point. This is Nancy again, back in the California offices. Go ahead and let us know about your challenges. All right, Jonathan, if you'll close out the poll, let's look at what we got here. So pretty, well, interesting. Only a very small percentage who said that it's not about a shared mission, but training and partnerships, staffing challenges, as we all know, you know, are critical at times, both in the changes that occur in staffing with new staff coming on and differences in positions, as well as the ever-present challenges of resources. And we note that earlier in one of the questions or comments that came in, the resource issues that challenge all family drug courts in looking at both scale and scope issues and being able to take on additional populations. We turn to a little bit of time for some questions, and a few questions that came in. If you have others, please do go ahead and send those through the question and answer box at the bottom of your screen. But first, Judge Salanitro, thank you so much for your presentation today and the emphasis that you're looking at with co-occurring disorders. Really a two-part question. First, are you anticipating that all parents will have a mental health screen and assessment process, or how will you determine who will get those kinds of assessments?
It is my understanding that all parents will receive the same screen and same assessment. We may have on a number of cases the new case. Well, you know what? Let me rephrase that in a sense. We already do a screen, which we are now enhancing and adding, and I mentioned that going back to the modified mini and the trauma assessment. We have changed our process and will be doing all these new assessments on every parent that comes through our system. So whether or not they have already been identified with a diagnosis, they will be receiving the same screens. We may hope to identify cases that need to be referred for further psychological assessments and evaluations. We will also have parents who will be coming in, presumably having had months, perhaps years of treatment and diagnoses, who are already in ongoing services for those conditions, and now will be enhancing that with the drug protocol. But yes, everybody will be receiving the enhanced assessments.
Great, thank you for that. And we note that Jeff Kushner from Montana commented and asked a bit of a follow-up question to that, noting that a significant proportion of individuals who come into substance abuse treatment and to come into drug courts often have mental health diagnoses in early stages that over a period of stability and recovery may in fact no longer meet criteria for that diagnosis, or may have resolved some of those mental health issues. Are you familiar with, or is anyone of the other panelists, how do you address that reassessment over a period of time to address some of those challenges about how individuals change as they become stabilized?
Well, it is our expectation that there will be constant changes, and that's probably a good thing. But we do intend on, and it's already been acknowledged by our service providers, that there will be frequent and regular reassessments.
Great. And Jane, I think what was your response to some of those issues about the assessment processes and reassessment based on your experience with family drug courts?
Well, thank you, Nancy. I would say that certainly just to reemphasize the importance of reassessment, that's critical, and that's certainly what I've seen across the country. To borrow from the 12-step community, assessment should be a process and not an event, in the sense that it isn't just it isn't something that should just be happening once, that there are so many factors that are dynamic in parents' lives, and they're receiving treatment, they're receiving other types of services that absolutely change some of the outcomes and some of the results that you would see from assessment and even some of the evaluation. So there's a real focus, and often that can be the piece that the clinicians and the psychologists and even psychiatrists can discuss with the team who may be less familiar, especially at the beginning, maybe less familiar with certain tools, certain instruments that are used, some that are appropriate at certain intervals, and understanding exactly what that reassessment process and frequency should be, and what the results mean, what they can tell the team.
Great. Thanks very much for that. Interesting issues for all of us to grapple with as we look at the scarce resources for mental health services and how to apply those and to make sure that we're doing those follow-ups. Let me switch to a bit of a different topic and another question really directed to Dr. Almeida. About curricula for children that are in this young age group, the 0 to 5, as we saw this large proportion of kids who are in out-of-home care in that age group. What kinds of suggestions would you have for other family drug courts that are looking at serving the 0 to 5 population in terms of curricula?
Well, thank you for that question. And you know, I'm always very hesitant in recommending any specific curriculum. There are some evidence-based programs out there that have shown some really great research in terms of parenting programs. I think what's really important is to really individualize curriculums and to individualize interventions. You know, so I cannot overemphasize the importance of a really good assessment, an integrated assessment. So, you know, if you're going to develop a curriculum for a child, you need to know what are the needs of that child, what's the parenting capacity of that parent or family, and what's developmentally appropriate for that child. So again, I just really need to emphasize the importance of that. And also that parent-child relationship. If you're, you know, if we recognize that relationship is so critical to a child's development, we really need to focus more on developing that parent-child relationship, and then making sure that whatever curriculum we choose, as long as, of course, it's evidence-based and a best practice and research, has a component to deal with that parent-child relationship. There is also, I mean, I would, Dr. Lynn Katz with the Miami Child Wellbeing Court, I mean, they've done some excellent work. They've been working on this for years, and we had the opportunity to have her come and be one of our speakers at the kids conference. Not only have they developed a great program, intervention program, and but she also has resources that she can share with other folks, and I know that those are readily available to folks. So I believe that there's a reference to the Miami Child Wellbeing Court model, and again, Dr. Lynn Katz, and she's developed implementation manuals, clinician guides, and they're available to share with others. So.
Thank you very much, Connie. And Dr. Katz was one of the speakers on one of our prior webinars, and we'll send some links to some of those materials and post those on the blog spot to make sure that all the folks that are participating today get access to that information. So thanks very much for that response. Let me turn things over to Jane Pfeiffer again to talk about some of the resources and next steps for Children and Family Futures.
Thank you, Nancy. Thanks, everyone. So in the interest of time, I'm going to go through these slides very quickly, but these next slides are some additional resources, some of which we've mentioned throughout the webinar, and the links are available on our blog, and we hope that you take a look at all of them. So this is, these first couple of slides are about serving parents with co-occurring disorders, and these next three slides really speak to all of the publications that focus on a broader audience. So you should note that these slides that you're looking at here are, while mostly not specific to family drug courts, they cover very specific, very useful information, and very comprehensive information for serving these parents and families. They can assist in the planning process, but really for any court that's interested in enhancing the work that they're doing in this area serving these families. I want to draw your attention for just a moment to the report to Congress. If you take a look at that, it's a very comprehensive and some have said overwhelming report, but it provides, among other things, information on funding barriers as well as numerous examples from specific states. And so again, all of these are very useful and very helpful. I draw your attention to that one for a moment. This is the toolkit that we discussed earlier. Again, it has specific training modules that can be pulled apart and used individually as teams look for ways to enhance their understanding. And now we'll focus on children ages 0 to 3. You heard Dr. Almeida talk about 0to3.org, and this is specific information and to really help to learn more about serving children in your program, but also provides information to assist statewide policy development and that on that 0to3.org site. These two that you're looking at now, the Miami Child Wellbeing Court model, these two documents are very useful. Some of you, I'm sure, have seen them already, but they're really worthwhile and very accessible documents in the sense that they can be useful to your entire team. What we call the guidelines document, Guidance to States, Recommendations for Developing Family Drug Court Guidelines. This was just released in May by us, and this is the document that I referenced earlier when we were talking about the Queens Family Treatment Court site visit. The guidelines really are they're a framework, and they can be used in just a number of different ways to assist policymakers and practitioners to enhance and expand programs, whether you're in the planning, implementation, or operations phase, and a number of different ways in which they can be used. So we've talked about this a couple of times, but we have two upcoming webinars, two upcoming learning as part of the Learning Academy. You can register for both of them. This next one, you'll notice, though, is in 2 weeks. We just want to bring your attention to the fact that instead of being a month from now, it's actually in 2 weeks. So please look to register. And then Raising the Bar in Family Drug Courts is a look at the Family Drug Court Guidelines document. So this will be our last webinar in 2013, and it's a chance to review that guidelines document and to really look at not just looking at the document, but really realizing ways to operationalize what information is in there. And then last time we're going to mention the blog, but I know some of you probably maybe have not seen our blog, but please take a minute to visit it. The resources and publications we've mentioned are out on the blog. It also provides an opportunity to ask questions, certainly questions that there wasn't time to answer during this webinar, and to and to get some response to that, and also to read the questions and answers that others have provided. So I want to thank you for joining us. We really look forward to your feedback. In a moment, when the webinar concludes, you'll be taken to an evaluation. We promise the evaluation takes only really literally 1 or 2 minutes. So we'd really encourage you to help us with the feedback that you can provide. And lastly, we here at Children and Family Futures want to thank you for participating, and we want to thank you especially for the extraordinary work that you're doing every day in serving children and families in your communities. With that, I'd like to turn it over to my folks back in the office, and please have a great day.
Yes, let me echo that. Good day to everyone. Thank you so much to our speakers today. We really appreciate the time and effort that you've put in. Let us know if you have additional questions that you'd like to ask any of our speakers or to Jane or myself. With that, we'll let you go a couple minutes early. And for those on the West Coast, now you can enjoy your lunchtime. Thanks so much, everyone. Bye.